Welcome back to Law Simplified. In our previous masterclass, we tackled offenses under the Penal Code. Today, we are opening Chapter 5 of our criminal law syllabus and stepping into a different statute entirely, the Sexual Offences Act of 2006. So, when it comes to sexual offenses, the definition of the actus reus and the mens rea shifts dramatically from the standard criminal law. The courtroom battles here rarely revolve around whether a physical act happened. They revolve almost entirely around one single powerful legal concept: consent. Let's break down the law. Before we charge anyone with a crime, we must understand the foundation: what makes an act sexual in the eyes of the law, and what constitutes valid consent. Under the Sexual Offences Act, consent means a person agrees to a choice and has the freedom and capacity to make that choice. So let me give you an exam trap. For consent to be valid, the person must have the mental capacity to give it. If a person is heavily intoxicated, unconscious, or asleep, they legally cannot give consent. If the accused proceeds anywhere, the mens rea is established because they acted recklessly regarding the victim's capacity to give out consent. Furthermore, consent is active and ongoing. If two people agree to an act, but halfway through, one person says stop, consent has been officially withdrawn. If the other person continues, even if 1 more minute, the actus reus and mens rea for sexual offenses are instantly established from the moment the word stop was ignored. Now let's look at the heaviest charge in the act, and this is the offense of rape under section 3. The actus reus here is the intentional penetration of the vulva, vagina, anus, or mouth of another person. The law is clear: penetration, however slight, is sufficient to complete the offense. The mens rea here is the intention to penetrate and the knowledge that the other person does not or did not give consent, or acting recklessly as to whether they consent. The penalty here is a minimum of 10 years, but up to a maximum of life imprisonment. Then let's go to defilement. Some other jurisdictions define this as assault by penetration. This is on Section 8 of the Sexual Offences Act. So what happens when the victim is a minor? While textbooks might broadly call it assault by penetration, penetrating a child under 18 in Kenya is specifically charged as the offense of defilement. So one key thing here is this is a strict liability case. A child cannot legally consent to sex at all. They cannot. So let me give you a scenario. Even if an accused argues she looked 21, she had a fake ID, she initiated it, the court will reject this. Why? Because defilement is a strict liability offense regarding age. Mistake of age is legally blocked as a defense. The actors in mens reas are just as the same as rape. The penalty is graded according to the victim's age. If the child is 11 or younger, the penalty here is life imprisonment. But if the victim is aged from age 12 to 15, the punishment is 20 years. And if the victim is aged 16 years to 18 years, the punishment is 15 years. While rape and defilement makes the headlines, the Sexual Offences Act is incredibly expansive. Here is how the law categorizes other violations done to the human body. The first offense, sexual assault, under Section 4. The rule here is simple. This all covers the intentional sexual touching or the act that do not amount to full penetration. So let me give you a scenario. If you're in a crowded matatu to the CBD, a passenger intentionally gropes you. Because there is no penetration, it's not rape or defilement. But the intentional, non-consensual touching of a sexual nature makes it sexual assault. Then let's go to indecent act, section 11. The rule here is any person who commits an act of gross indecency with another person or exposes themselves, they have committed the offense of indecent act. Let me give you a scenario. A person stands in a public park and intentionally exposes their genitals to shock bystanders. There is no physical contact with the victim, but the act itself is inherently indecent and punishable under the law. Then let's go to sexual harassment under section 23. The rule here is any unwelcome sexual advances, request, or physical contact, specifically emphasizing abuse of power, leads to the offense of sexual harassment. Let me give you a scenario. So if a university lecturer tells a student, if you want to pass this unit, you need to come to my hotel room. This is a classic quod and quo case. This for that. Abuse of authority. The words alone constitute sexual harassment under the Sexual Offences Act. So let's go to an offense not talked about too much. Deliberate transmission of HIV or any STDs, sexual transmitted diseases. This is an offense under Section 26 of the Sexual Offences Act. The rule here is the law criminalizes knowingly infecting another person with a life-threatening sexually transmitted disease. So let me give you a scenario. Juma knows he is HIV positive. He meets a partner, deliberately hides his status, and insists on unprotected intercourse, thereby transmitting the virus to the partner. His knowledge and deliberate concealment establishes the mens rea for this specific severe offense. How can you defend a client in a sexual offense trial? A common exam trap is to think there are no defenses for sexual offenses, but how you argue is what makes you win a case. So here is how you marry the legal concepts together in a courtroom. 1. Consent. This one is for adults only. We said for minors, consent can never be given. In a rape trial, the primary defense is proving that the act was consensual. If you can prove a valid ongoing consent, the mens rea of the crime collapses. Then we have the no defense trap for minors. So for defilement, you must remind the court that it's a strict liability offense. Consent and mistake of age are legally invisible. Then we have general criminal defenses. Regardless of how strict the charge is, general defenses always apply to the actus reus. An accused person can always plead alibi. I was in Mombasa when this happened, and it happened in Nairobi. Then you have mistaken identity. The victim identified the wrong person, or physical impossibility, medical inability to commit such an act. Then let's move on to a case where there is false allegation under Section 38. So we must also address the reality of the legal system. So what happens when the law is weaponized? We often hear stories of land disputes or bitter divorces where the individuals are falsely accused of sexual offenses to send them to prison. So the drafters of the act anticipated this under Section 38, false allegation. The rule here is the reversal of the penalty. If you falsely accuse someone of rape, which carries a life sentence, and the court proves you knowingly lied to frame them, you will be liable to suffer the exact same punishment that the accused would have received if they were charged of the same offense. Sword swings both ways, not just one way. So to wrap up this class, I want to leave you with a high-level academic thought. We've established that sexual offenses require a living person to give or withdraw consent. What happens when the victim is deceased? Necrophilia is the offense. This is a massive gray area in the Kenyan law. Because a corpse is not legally a person, it lacks the capacity to consent, which completely breaks down the legal formula for rape under the Sexual Offences Act. So instead, prosecutors must rely on the Penal Code. They charge it under Section 136, which is offering an indignity to a human corpse, or Section 137, harming a dead body. Both of these are classified as merely as misdemeanors. The law currently treats the sexual violations of a corpse more like vandalism or trespass than a severe sexual offense. So what are your thoughts on that? Should it be a sexual offense or to remain as how the law is? So for those studying mortuary or management or posthumous dignity, this is a series of legislative gaps that the future lawmakers must address. Mastering the Sexual Offences Act requires a strict understanding of capacity, consent, and the specific statutory boundaries. If this lecture helped you, hit the like button, subscribe to Law Simplified, and share this with your friends, your classmates, your colleagues. Let's keep simplifying the law one case at a time. Thank you.